You know, some stories start out simple, but end up being about something huge. This is one of those. It starts with a pretty standard traffic stop, but believe me, it ends with the entire idea of justice itself on trial. It's a case that makes us ask a question that really gets to the core of our legal system. So let's dive right in. What on earth do you do when the one person in the room who's supposed to be completely impartial gives you every impression that their mind is already made up? Okay, so let's set the scene. It's just after midnight, November 1st, 1999, on a busy highway in Toronto. A police cruiser flashes its lights and signals a driver to pull over. Simple enough, right? Well, the reason why he was pulled over, that really depends on who you ask. And right from the get-go, the two stories could not be more different. On one hand, you have the officer, Constable Olson, who says he saw the vehicle flying down the highway, weaving between lanes. On the other hand, you have the driver, Mr. Dakovin Brown. He says, no, the police jeep pulled right up beside me, the officer looked straight into my car, and then he pulled me over. I mean, these are two totally different versions of what happened, just moments before the stop. So who are the people involved here? Well, we've got Dakovin Brown, who is a young, black, professional basketball player. He's driving a brand new, pretty expensive SUV. He gets stopped by Constable Olson. Now, the official charge was for impaired driving. But here's the thing. The real battle in the courtroom wasn't going to be about the breathalyzer test at all. It was all about the why. The defense team's whole strategy was to argue that the stop itself was completely illegal, that it had nothing to do with speeding, and everything to do with something way more disturbing. And that's where this term comes in, racial profiling. The defense argued this was a classic case of it. Now, the legal definition is pretty clear. It's targeting someone not for what they've done, but because they belong to a group that's stereotyped as being more likely to be involved in crime. And this is a really, really important point. The defense wasn't necessarily trying to prove that the officer was some kind of cartoonishly overt racist. No, their argument was much more nuanced. They were saying his actions could have been driven by subconscious stereotypes, a kind of unconscious bias that just kicks in without you even realizing it. So how do you even begin to prove something like that? It's not like an officer's gonna admit it, right? So you have to build your case piece by piece with circumstantial evidence. The defense argued, look, you have a young black man in a fancy car. That fits a certain profile. They poked holes in the officer's testimony, pointing out all these inconsistencies. But the real bombshell was this. They found evidence the officer ran a computer check on Mr. Brown's license plate before he even turned on his flashing lights. That suggested he was already suspicious, already investigating, maybe looking for a reason to pull him over. But this is where the story takes a really sharp turn, because as the trial went on, the focus started shifting away from the officer's actions on the side of the road and onto the judge's own words inside the courtroom. It started subtly. The defense lawyer is cross-examining the officer, trying to get to the bottom of those inconsistencies, and the judge just jumps in. He calls the allegations of racial profiling very serious, and then tells the lawyer that he finds this whole line of questioning a little troubling. It's a small comment, but it's the first sign something's off. But it didn't stop there. Later on, when the lawyers are making their final arguments, the judge's language just explodes. He calls the entire racial profiling defense really quite nasty, malicious, potentially, accusations based on, it seems to me, nothing. Wow. I mean, he's not just troubled anymore. He's actively describing the defense's argument in these incredibly hostile terms. And then came the final blow. The judge finds Mr. Brown guilty. And during the sentencing, he actually turns to Mr. Brown and suggests that he should apologize to the police officer because the judge was satisfied the allegations were completely unwarranted. Just think about that. That one comment would become the absolute centerpiece of the appeal. Okay, so this series of comments from the judge, it's not just bad form. It raises a massive legal issue. It forced a higher court to ask a very specific question. Did the judge's behavior create what's called a reasonable apprehension of bias? And there's a whole legal test for that. Let's break this down, because it's so important. The test isn't about proving what the judge was actually thinking. It has nothing to do with getting inside his head. It's all about appearances. The question is, what would a normal, informed person watching this whole thing unfold conclude? Would they walk out of that courtroom thinking, yeah, it's pretty likely that judge couldn't have been fair? So, this reasonable observer isn't just some random person off the street. You can think of it like a 4-part checklist. First, this person knows the facts of the case.
Second, they're realistic and practical about it. Third, and this is so crucial, they are aware that things like racism and stereotypes actually exist in our society. And then fourth, based on all of that, they make a call. Is it more likely than not that the judge just couldn't be impartial? So, with this legal test as their main argument, Mr. Brown's lawyers appealed his conviction. They argued that the trial judge completely failed this reasonable observer test. And now the appeal court basically had to deliver a verdict on the original verdict. And the result? It was a bombshell. The appeal was a success, Mr. Brown's conviction was completely thrown out, and a brand new trial was ordered from scratch.
So why? What made them do it? Well, the appeal court said when you add up all of the judge's comments, it gives the undeniable impression of a closed mind. They said his resistance to even hearing a racial profiling defense was just palpable. He kept using these loaded emotional words like nasty and malicious, and his focus seemed to be more on defending the officer's feelings than on protecting Mr. Brown's rights. And that final suggestion of an apology, well, that was the nail in the coffin. It just cemented the whole appearance of bias.
And look, you don't have to take my word for it. Here is the key line, straight from the appeal court's decision. They found that a reasonable person watching would have felt that the trial judge showed such, and I quote, antipathy and resistance to the whole argument that he was just flat out unable to hear and determine it with an open and dispassionate mind. At the end of the day, the case of R.V. Brown is just this powerful, powerful reminder of one of the most basic rules of our entire legal system. It is not enough for justice to be fair. It has to be seen to be fair. The appearance of justice matters just as much as the reality of it. And that's really the big question this case leaves us with, isn't it? It's not just a question for judges and lawyers, but for all of us. In a world where we know that biases, conscious or not, are real, what do we have to do to make absolutely sure that justice is always truly seen to be done for every single person who walks into a courtroom?